Evening, calling to order the November 29th, 2017 meeting of the ZBA. There's one matter on the formal agenda tonight. It's an appeal of Mr. DePietri relative to a notice of violation issued by the building inspector regarding the Stonebrook Village condominiums under construction on Oregon Road. Karen, would you please read the public hearing notice into the record?
Before we do that, should
Yeah, you'll, hold on.
Notice of public hearing, William A. DePietri, Absolute Realty Trust, 17 Oregon Road in 0 Stonebrook Court, Southborough, Mass. The Board of Appeals of the Town of Southborough will hold a public hearing in the Thomas J. McAuliffe Hearing Room of the Southborough Townhouse, 17 Common Street, on Wednesday, November 29, 2017, at 7 p.m. with regard to the appeal of William A. DePietri, Absolute Realty Trust, relative to the notice of violation issued by the Building Commissioner on October 12, 2017, mandating compliance with conditions of approval. Appearance in accordance with the requirements of General Law, Chapter 40A, Section 15. A copy of the application may be reviewed at the office of the Building Department located at 9 Corderville Road, Southborough, Mass. During normal business hours. Andrew R. Dennington.
And before we begin, Mr. Bartolini's told me he wishes to make a statement regarding his participation in the hearing.
I have a public comment to make that I have received a decision from the State Ethics Commission that I do not have a legal conflict of interest with Mr. DePietri at all. The other issue is that they've stated that I should file a disclosure application with the Board of Selectmen, which I did the other day. And in that, they said that I should state one thing of the reasoning behind all this, to explain it. And the issue is that myself and my brother, Paul Bartolini, we owned a self-storage business around 2005. The Rosewood Development Company, which is owned by William DePietri, rented storage areas and full market rent for approximately 6 years. And Mr. DePietri stopped rental of these units within a year. Thank you.
Okay. Mr. Catanzaro, would you like to make a presentation?
I would. It's a pleasure to be back. I haven't been here for a while. I'll make this brief because I think that this is a simple appeal, yet the issues are rather straightforward. What we are not appealing, okay, is that the conditions of the definitive subdivision approval, okay, or the major site plan approval issued by the planning board, both in October of 2013, that we are not contesting that they apply to the construction of the 15-unit condominium project. This violation arose because of alleged conduct, construction activity on lot 1 of the subdivision, okay, which has nothing to do with the 15-unit condominium project. The subdivision approval, like I said, allowed for 3 lots, only one of which the 15-unit condominium project was going to be constructed on. So any of the conditions within any of the approvals that apply to the condominiums, we don't challenge. That's what they are. None of the conditions, okay, that the building inspector sought to enforce apply to either Lot 1 or Lot 2. Now, in his notice of violation, the building inspector makes a couple of comments. I have it right here, okay, which I think adds to the fallaciousness of his decision. Okay, number one, the special permit was not issued to Mrs. Arsenault, who owned the adjacent property, which we now own. Okay, after the subdivision was approved, we did ultimately acquire the land from Mrs. Arsenault. So she is not a party to the special permit. Number two, the special permit has no conditions attached to it. If you look at the record, there's no conditions to the special permit. The definitive subdivision and the major site plan approval do have conditions, okay? And those are the conditions that we have to abide by, but the special permit certainly doesn't. Also in his letter, the building inspector cites reference to a bylaw, and he states that special permits issued by the planning board require work, et cetera, et cetera. Well, this was not a special permit issued by the planning board. This was a special permit issued by the zoning board of appeals. If you look at the decisions for the definitive subdivision, and if you look at the decisions for the major site plan review, it is patently clear, okay, that each condition, the entire 8, 9, 10, 15 pages of them, okay, only apply to the 15-unit condominium project. In fact, okay, if you go to the very first page of the conditions of approval in paragraph 2, it states, "The project shall be constructed in substantial conformance with the plans and submittals. The development shall be configured to consist of a total of 15 condominiums within the maximum of 30 total bedrooms." That's the project. Thereafter, throughout the document, throughout the decision, throughout the conditions refer to the project. You will find nothing in any of these documents that relate to the use or development of lots 1 or 2. More interestingly, and I apologize I didn't attach it, but the decision for major site plan approval in its opening statements says specifically, the site plan review is for Lot 3 of the 15-unit and over 55 condominium project. It's really clear that when these approvals were handed down by the planning board and by the zoning board, that this focus was on this condominium project. The fact that there are 2 residual single-family building lots clearly does not fall within the purview of any of these decisions. And, you know, how and why the building inspector came to that conclusion, I noticed that he's not here tonight, okay, I don't know. I mean, I do know that, and I think it's clear in this town that there was a history of litigation involving this project, okay, that went on for the better part of 3 or 4 years, that went all the way up to the Supreme Court, and at every level was rejected by the courts, okay? And it is my understanding that the same proponents of those appeals were the ones who complained about this activity on Oregon Road on that morning when the building inspector told them to no longer do it. So, I mean, our position is very simple. We know we have to abide by them with construction of the condominium project. It has nothing to do with the construction of 2 homes or single-family homes or whatever else we're going to do on lots 1 or 2. And that's, in essence, our position.
Anyone want to ask any questions, or you have anything else to add?
May I start?
Well, let's first go down in the usual order. So, Ms. DeMaria?
Okay, so in the planning board definitive subdivision definition includes, the subdivision is limited to maximum of 3 lots as shown on the approved plans. Lot 1, which is existing daycare building and garage and proposed single-family house on Lot 2, and a 15-unit over 55 condominium. So, to me, that corresponds to that number 8 that the building inspector is referring to, because there's a provision. So I'm just wondering if you can tell me, what was the thinking? Did you disagree with that at the time, or because there is the number 8 that the building inspector points out in Appendix A refers to,
I know what it refers to.
Okay,
and
thanks.
And I can answer your question.
Okay.
That is very typical, and I would say, but I can't speak for every decision rendered by the planning board in this municipality, but it basically says that the sale of our property, okay, that it is binding on anybody, any successor in interest, anyone who purchased the property. So if we sold the property, We're subject to the conditions of that apply, if they apply. Okay. That's it.
So do they apply? Because according to the decision, the planning board says the subdivision is limited to the 3 lots, and they name 1 and 2.
Well,
As
when
well.
we were subdividing a large parcel into 3 parcels. On one of those parcels, okay, we had a special permit to build a 15-unit, age-restricted condominium. They granted us a 3-lot subdivision. They issued conditions, okay, regarding that 3-lot subdivision, but they specifically tailored those conditions to the condominium. I mean, all you have to do, Mr. Moria, is read the conditions. It's not rocket science. They talk about the condominium project. They talk about the infrastructure for the condominium project. They talk about the septic systems for the condominium project. There's nothing in there that handcuffs us or conditions the use of those 2 other subdivision lots. I mean, that's our position. This is more or less boilerplate. And I would suggest that language similar to this is in every definitive subdivision plan that is approved by the planning board. I think more telling is the fact that when you look at the site plan approval, which approved the very same plans that were approved by the planning board for the definitive subdivision, it was a little bit clearer that it only applies to Lot 3 and not to the other 2 lots. This is, you know, in our view, this is just an attempt to try to curtail our ability to build these other 2 lots under normal circumstances. The hours that are imposed are not what is imposed on any other residential subdivision, and I guess they were, okay, what's that?
Single-family house.
Or single family, all right, and I guess they were appropriate because we were building the 15-unit condominium. But again, I think the documents speak for themselves. And if you can find a reason why those conditions, okay, apply to those single-family lots, you're a better reader than I, because they're not in there.
Okay, so I just have, thank you for that, and I have one other question, because I do agree that sometimes things are written, and I think this might have been a meeting that went late into the night. I noticed with a lot of the conditions, numbers were out of order. But the definitive subdivision plan has all 3 lots on it, does it not?
It has to. That's what it is. A definitive subdivision approval is the planning board's approval of taking 1 parcel of land and dividing it into 3 building lots. That's what it does. The planning board has the discretion to issue conditions, okay, in granting that right to subdivide. They did. Those conditions, as they wrote them, okay, applied to Lot 3, not Lot 1 and 2. It's clear.
Which we didn't own. We didn't own Lot 1 and 2. I mean, you can have multiple owners file for a subdivision approval. So they granted the 3-lot subdivision. Only our lot, we went back to the planning board and the zoning board and got a special permit for, and got the conditions for the 15-unit project. Lots 1 and 2 still belong to Arsenal, nothing to do with our filing, other than the subdivision approval. So the subdivision could have been subdivided, and we could have come back a year later and got our permits for our single lot outside of Mrs. Arsenal's.
Okay, thank you.
David?
I'm a little bit hesitant to ask because I'm probably going to be just following up on what Ms. DeMuro is asking, but I'm, as I follow it, and I think, I apologize, you just described it, but the definitive subdivision applies to the 3 lots, but I think where you're coming in is in Appendix A, Conditions of Approval, Paragraph 2 says, the development shall be configured to consist of a total of 15 condominium units with a maximum of 30 total bedrooms. So, again, the definitive subdivision is just legally dividing up what exists there, correct? You've got 3 lots, and at the time, one of the lots you didn't even own.
2 of the lots, they didn't even
2
own.
of the lots you didn't own, okay. Right,
And the only reason why we did that, because the town of Southborough, you can't have a 1-lot subdivision.
okay. All right.
Otherwise, we wouldn't have had to even do it. We could have just gone in with our 1 lot, but that's not legal, so we had to subdivide it into 3 lots.
Okay, all right. Yeah, I think, as I look at this, it doesn't I guess I'm not seeing where it says, it clearly says this applies to Lot 3, but it does seem like I could look at Appendix A, Paragraph 2, and I think I don't know, I see exactly where you're coming from, that the rest of what follows sort of fits within what's defined right there, very early in Paragraph 2.
Yep.
Okay, that's all I have, thanks.
This might be a silly question,
Nope.
but we're talking about a notice from the building inspector where the remedy is, please don't build on holidays and pay a $300 fine.
I don't think there was a fine issued, though. There was no fine.
There's no fine, so not even a fine issued.
No.
Is there a larger reason why you're even appealing
No,
this?
He's basically looking for the 2 single-family house lots to fall under everything under Appendix A.
Okay, that's the answer to the
And that's
question
the
then.
issue.
Yep.
I mean, fine, we won't work on holiday,
So
It's the
that's-
hours of operation, it's just one thing after another, Look, we agreed to it on the 15-unit project, we're doing it, but these are outside of it.
Okay. Do you have an issue of following those just the hours of operations?
I do,
Okay, why?
because the subs don't want to go home at 2 o'clock on Saturday.
Okay, what about holidays?
Look, these 7 major holidays, they're not going to work. If these,
Columbus Day?
Exactly. I was going to use another word, but those holidays, they want to, look, the more we work, the sooner we get done, the quicker we get out of there.
Yeah, okay. I do see your points on the subdivision shall consist of. I also see in Section 8 that the specific provision of it be binding on successors and assigns is of Absolute Realty Trust, not Mrs. Arsenault.
Correct.
So the conditions of Mrs. Arsenault, which don't get discussed at all, don't have that same item number 8 provision that it follows with the land and not with the owner. So, okay, I'm good, thanks.
One of the issues is that the zoning board, I was a member of the zoning board when we did the original one on this, and there was no discussion of any of this. There was something brought up by somebody, and it was stated that it was nothing to do with you people at all, or anything. My major issue on what the building inspector did is, and for many years, I've built many houses in the town of Southborough, individually, singles, doubles, or whatever. We have no rules and regulations of construction time, 24 hours a day, 7 days a week. There are none. The only rules and regulations, comments that were made, which, what do you call, stated, is the 7-day of holidays. But there are no other rules and regulations on any construction of either commercial, either subdivisions or individual houses in the town of Southborough.
You have any further questions, or? That's it?
No, I mean, the question I asked is, do you remember?
Well, no, I know that there are no regulations regarding construction activity, okay, that hasn't been specially permitted, okay, or hasn't been the subject of some sort of approval that a board has some jurisdiction over. If I bought a single-family existing A&R lot, okay, I don't have to limit my construction to any time. I can just build, okay, I can do what I want to do. The planning board exercised its authority, okay, and it said, well, hey, when you're building this large project, we'd like you to abide by these conditions. And we did, okay? I mean, the issue that and again, they appealed the special permit, but they never appealed the definitive subdivision. They never appealed the site plan approval, okay? So these conditions have been out there on the table for a long time. And I think the building inspector's letter is just clearly wrong. I mean, from top to bottom, okay, he's saying that it's a condition of the special permit. It's not. He's suggesting that the special permit was issued by the planning board. It wasn't, okay? And so it's clear to me that the board should overturn his decision and just let us proceed in the ordinary course. And we assure you that we're going to abide by these conditions when we're building the condominium project, which we are in the process of and which we have. Okay, the complaint came when there was some construction activity on, what day of the week was it?
Saturday.
On a Saturday. That was the complaint. And, you know, and we think that the building inspector was wrong, and we'd like an opinion from this board, a decision from this board, saying just that. Okay? That his opinion was wrong because those conditions do not apply to lots 1 and 2.
My other statement that I made was, there was no discussion of these two houses when it was in front of us before, right?
No, there was, when we were before your board, okay, and as you would note in the decision, we had plans of subdividing the property and of constructing the project just on Lot 3. But once again, we're before you and the planning board at the same time, and the planning board preferred that we get our special permit first, then go back to them, okay, so that they could tailor their definitive subdivision approval and their site plan approval to because at that moment, they didn't know whether or not we were gonna have permission to build the project. So we got the permission from this board, and then we immediately went to the planning board and got the permission from the planning board.
When you go to build these two houses, basically, and I personally know, but I'm curious what you have to state, do you figure your time of, it will take you to get those two houses framed in and closed up? Because once you're inside, you don't make any noise, but when you're
No.
framing, I mean, what do you think will take the time to do that?
From putting the foundation in to getting it framed and pretty much weathertight is probably 3 months.
Okay, I'm all set.
So I wanted to ask you for the construction that generated the complaint, was that for work on Lot 3, the 15 unit, or was it for the single-family home on Lot 2?
Where the daycare was.
Where on Lot 1, where it was the tearing down of the daycare home, of the structure that once was the daycare.
And that's just now done, right?
Right.
That's done, right.
Okay, so, I mean, I live fairly close to there, so I've driven by it, and I remember in the summer, there was like a water tank, a mobile water tank that was parked where the daycare center was. It looked like that was used to water plants along the, so it looked to me like lots 1 and 2 were kind of being used as kind of like a staging area or some type of a place to do work for the units. Like, I remember the last time I saw it, there was just a very big mound of soil on one of the lots. Is that right?
I
Mr.
don't know.
Andrew, I want to correct you on one issue. The water truck which was there was put there for the abutters that requested the dust issue on the property. And they had to take and water the driveway all the time to keep the dust down. That's why that truck was there, through the
Okay.
building
And
inspector.
my question was really addressed to Mr. Catanzaro and Mr.
But I'll have Mr. Petrie answer that, because I don't know the answer.
So,
I guess, so
Sorry.
I was just, here's my observations, right? I've driven by, I'm just interested in following it, and I see, there's maybe 3 or 4 of the condos that are built on, like the north side, right? And there's a lot of work to be done in the back. But there's nothing that's been done. It looks like you have a plan to build a single-family home on Lot 2,
yes,
which is kind of in between the frontage parcel and the back.
right.
Has anything happened on that?
Well, we just got the building permit on that lot there,
When?
maybe a couple weeks ago, 3 weeks ago.
So
As soon
was
as the
it-
building inspector came back from vacation,
So was it before or after?
after.
Okay, this complaint, was it Columbus Day or was it a Saturday?
It was a Saturday, I don't remember the holiday, but the complaint was we had a demolition permit for the old daycare. We don't have a building permit yet, we're going through, stormwater
Yeah.
management right now.
So, I mean, just how I kind of come at this is that, I've read all the conditions pretty carefully. And I agree that, the subdivision, the planning board's decision of definitive subdivision, Stony Brook Village, that does apply to all 3 lots, because it was to divide 2 lots into 3 lots. And it does make sense that Schedule A, the part which says project construction, that the project is the 15 unit. But, you know, it doesn't, it uses the term "the property," "the site," and it's not very clear what it refers to. In here, it just says, "Construction, including materials or equipment delivery, shall not commence on any day before 7 a.m. and shall not continue beyond 6 p.m. except on Saturdays," et cetera, et cetera. So, I mean, I view it as kind of a close call. I'm not sure exactly what that meant, so when it is a close call, I'm kind of inclined to just affirm what the building inspector initially determined, because he's the enforcement officer, and if there's not some compelling, you know, reason.
But don't we have to look at what the building inspector wrote?
I agree that,
I mean,
like,
how
I
can you
couldn't
uphold a
find the number
decision
8.
that's not even predicated on accuracy? He's saying we violated a special permit. We did not.
Well, also, you were saying that, and maybe we'll hear from this from the abutters, but the noise complaint, Mr. Robidoux' letter says, "An inspection was conducted today in response to noise complaints received by neighbors relating to construction activity on a federal holiday." So I just assumed that that would meant, I don't know if Columbus Day is a federal holiday, but so that would not be Saturday, it would be something on it.
I think he
Monday.
meant,
It was a Monday.
it was Columbus Day. I
Okay,
mean,
You're right.
so are you?
whether it's a federal holiday.
Are you gonna, I understand, you know, there's a difference in this list of holidays, which are
Yes.
federal holidays. And I assume people aren't gonna be working there on Christmas but days like President's Day, or do you wanna have people working there on the site? or-
Just the 7 major holidays. I mean, these guys wanna, you know, they wanna get the house done.
Yep.
And the limit, the time, and the 2 o'clock on Saturday, that's why the project's going slow behind there. I wanna do these 2 houses up and done. I won't work on Sundays, I won't work on the 7 holidays, providing they're not making noise. If they're in there painting and doing tile work and not bothering anyone, they can work there. Right now, I can't even do that on the condominiums. There can't be anyone in there doing any work, whether they're making any noise or not, they can't be in there. So it's like tying 2 hands behind your back. And in the same sense, hurry up and finish the project.
All right. At some point, we should open it up for public comment, so think about, do you have
So-
some more questions for the
No,
applicant?
actually, it's just a comment on yours.
Okay.
I know where you're going in terms of, although it's on Lot 1, if the activity was related to Lot 3.
Yes.
I think in this specific case, since it was the demolition of the building on Lot 1, it's not so much, it's really a demolition permit for that specific lot.
I don't really know what it has to do with now,
Well-
because the building permit for, I'm
The
just kinda
demolition permit.
confused.
So I picked up on what he said, it was a demolition permit, and that's what they were doing, which is very specific to Lot 1.
So the demolition was going on Columbus Day?
Well, they tore it down on a Saturday and they were loading it out on a Monday, I believe.
It's gone.
So, I just wanted, because I do understand, and I do think you do have to be careful if you're using Lot 1 for activity on Lot 3. I think in that case, probably because the end effect of your work is Lot 3.
I agree 1,000% with you.
Okay.
Like what
We're on
Andrew
the same
pointed
page,
out,
yep.
if there's soils that are gonna be trucked from Lot 1 or Lot 2 onto Lot 3, that can't be done, okay? And if you did that at 5 o'clock on a Saturday afternoon, that's a violation. We're not talking about that. We're talking about these conditions saying we can't exercise our rights under the building permit that was just issued to us on Lot 2, just like everybody else in town can exercise their rights.
But the Lot 2 is gonna go, and could you speak to this, do you intend to finish the 15?
No, we're gonna build both these houses are together, one right after the other.
And is on the frontage lot, Lot 1, where the daycare center was 2 parcels, right?
It was
Okay.
one parcel, and we subdivided it into 2.
All right, so then Lot 1, is there gonna be a house on Lot 1 also?
Yes, yep.
So
Lot
does,
1 will front on Oregon Road.
they're gonna have this, like a shared driveway or something, or?
No, the other one has an easement,
Off of Stonebrook Court?
correct.
Okay. All right.
Good.
I mean, I've got some other thoughts, but we can talk about it when we're deliberating after hearing comments.
We can make some comments on some decisional issues also.
So at this point, I'd like to open it up for public comment.
If town council, I'll make a comment.
Mimi Luttrell, 19 Oregon Road. I'm a member of the planning board, but I am speaking solely as an individual. You know, what are we talking about here? Isn't it a matter of common courtesy? This development is not, you know, off 100 acres somewhere with no abutters. It's in the middle of established neighborhoods. And 5 days a week, 11 hours a day, we listen to the construction, and for 6 hours on Saturday. So why is it so hard to ask that we get Sundays and holidays of quiet? And this isn't the first noise complaint. There were complaints on Lot 3, but the building inspector didn't follow through with a violation letter. So this is a culmination of many complaints. And those lots are part of the subdivision. They have stockpiles from Lot 3 on them, and they're part of the subdivision approval. Thank you.
Good evening. Lisa Braccio, 13 Oregon Road. I'm speaking solely as an individual and an abutter to the project for myself. I'd like to touch on briefly why the conditions were put in place. And I know Mr. Bartolini sat when I had come, well, when the proponent had come before the board in the past. One of the reasons why the time conditions were put in place is I have a child with sensory issues, among other issues. And one of the main concerns for us was having construction so close to my home. And that was one of the reasons why that it was put in place. Saturday is his only safe day at home, and that's why the conditions for the time and federal holidays were also taken into place. The only reason there was a complaint on this, they took the building down on Saturday. No problem, they had the permit to do it. They're allowed to do it. No problem, they stayed within the guidelines of the time. Monday morning at 7 o'clock, I woke up to a child screaming because of excavators and trucks and lifting of concrete, dumping it into the back of a truck on a federal holiday that's listed and covered by the conditions. That's unacceptable to me. Yes, I myself did call the building inspector and say, we have a problem. Conditions were put in place such for issues as this. So that's just some background on the conditions. And the conditions actually, when this project was before ZBA as a 40B, the exact same conditions and times were put on it. Planning board paralleled the conditions on this project. The water truck, just to be clear, was also used not just it was used to water the road, which was very helpful during the summer before the binder coat was put down to keep the dust down as it blew across the road. It was also used to water plants before water was put in, just after the plants were put in. As far as the conditions, again, the conditions were agreed upon by everyone when this went before planning board. There wasn't an issue. There's no issue on building. They have the right to build on lot 1 and 2. Nobody said anything about that. The only complaint there is on lot 1 is that the time that was put and the conditions that are listed in the decision for that lot were violated. And we as a neighborhood, on what we deemed as a federal holiday and what's listed on the federal website as a holiday, the post office is closed that day as well. Federal employees don't work that day. So again, I don't think it's too much to ask for. There was no fine issued. There was no fine issued on this. It was just saying, please abide by the time conditions. And out of any of the issues we've had with this project going on next door, it's mainly been time complaints that we've had. If those were abided by, then there wouldn't be very many issues or anything for us to even be here to talk about. So I would appreciate if you could take that into your consideration. I know one of the things said here today was that the Arsenals were not an owner. I know if you look through the decision as well as the actual plans list the owners as Absolute Realty Trust and Mary Ellen Arsenault. These are filed with the Registry of Deeds as well. So please take that into consideration as well, and thank you.
Are there any other comments from the public?
I'd like to make a comment on what she said, stated.
Yes? I have just a quick question. Sure, why don't you come to the microphone? Let's wait till Mike finishes.
It's just what she said to help her make it.
Yeah, sure, just a second.
Michael Robbins, 47 Deerfoot Road. just as a quick question.
And also, Mr. Robbins is the new alternate.
Alternate, so I just didn't know the protocol on this, but in the decision for the subdivision, the total site is listed as 8.34 acres, tax assessor's map 15, lots 15 and 16. I've looked through all the plans that I have, and I've done literally the math, and none of the math matches up as far as square footage, and so I just don't know if I'm looking at the wrong plans, but what I've been provided with, lots, parcels, excuse me, map 15, parcel 16 would seem to encompass the lots 1 and 2 and 3, but I just can't make hide or hair of the math on it. But, you know, the subject property consists of assessor's map 15, lots 15 and 16, Oregon Road, total site is 8.34 acres. And then when I look at the subdivision plan that I see that's been signed, it says 6.5 acres, and it lists kind of this jog out as parcel 16 as well. So I just don't know what covers what, so I thought to bring that to the board's attention.
Mr. DePietri, do you know the answer to that, or?
I mean, I know the
I
answer.
wasn't, no, I wasn't listening, sorry.
Parcel, map 15, parcel 16 was the parcel that was owned by DePietri, by Absolute. The front page of the definitive subdivision shows the Arsenal lot, okay, with a map 15, parcel 16. I think that is not the correct parcel number, okay? So,
Oh, that's weird.
okay, so no, that's probably the engineers just put the wrong part, until Mr. Robbins pointed that out, I never noticed that. So the total amount of land is the combined, for the subdivision, is the combined DePietri and Arsenal property. That's how you do it. She had to sign the application. We're not contesting that the definitive subdivision plan, okay, and the major site plan was that Mary Ellen Arsenal was a co-applicant. She was. Her property was involved in the definitive subdivision. She had to be a co-applicant, okay, and so that's what occurred.
Okay. Question, the statement that was made is the fact that the board knows it. We had the landscaping and a fence put up next to her house, and we had it done in the beginning of the construction. It was one of the agreements by the zoning board that it would be done right away to help the noise and stuff for your son. Correct. And they did do that, am I right?
Yes, they did that, but that has nothing to do with the time conditions on the project. And yes, I appreciated the things that were done. There's no question, Mr. Bartolini.
Just wanted to
The
make sure the
fence,
board knew it.
there were things that were done to offset some of the noise for my son, absolutely, and the time being one of them. And I was very happy to have that condition put in. Thank you.
Okay, any other comments from the public?
I make a motion.
Let's, yes.
I would be curious to get council's advice on how he interprets conditions of approval. Just because, I mean, to me, I kind of see it this way. I guess I'm just looking for your opinion going through the documents, if in fact what they have listed here as the hours to you just applies to the 15 units of the subdivision.
Let me say this to you, that what was issued was in effect a courtesy notice of violation. Correct it and we'll take no action. In the alternative, the building commissioner could have simply issued a fine, and that appeal would have gone to the magistrate in the Westboro District Court. And there would be none of this evaluation at this level. What you're hearing is information relative to what constitutes the project site. Beyond the numbers and the quantifiers, what was the intent to put those conditions on this particular site? And what do you construe the site to be? 1 lot, 2 lots, or 3 lots? What constitutes the project site? You have to listen carefully to all the evidence. You listen to the applicant, the permit holder and his counsel, but you also listen to the specific information you're getting relative to what happened or what the construction of those conditions were. And there's in my mind even, there's a real question of the fact that the project site is 3 lots. That constitutes a project site. So, and what are we talking about? We're talking, first of all, Columbus Day is a federal holiday enacted by President Benjamin Harrison and then subsequently reenacted by President Franklin Roosevelt. It is a federal holiday, number one. Okay, there is no question about that. Any good Italian American would know that.
That's why
Now,
we're working.
having said that, it comes down really to what is the practical evaluation of what happened here? This is a subdivision, and it got a special permit, more or less shoehorned into a very tight-knit, densely populated neighborhood, and there was this condition about no noise. Does that mean that you can have no noise in the 15-lot subdivision, but that you can have noise on a federal holiday close to these abutters on the 2 lots that are construed to be not part of the subdivision? That's what you have to ask yourself, and you have to apply a reasonable standard in terms of looking at all the evidence, trying to understand the condition, and then you've got your zoning cop, because the building commissioner, in this case, is the zoning police. He made a determination. You have to question that, and then you have to make a determination if you're going to uphold the zoning police officer or you're going to overturn him. And if you do overturn him, it's going to require a supermajority.
Thank you.
I'd like to begin a discussion among the board members, and I think it makes sense to keep the public hearing open while we do it, so that if anyone has a question, you can always ask any of the interested parties.
One of the issues I think that should be properly done is that on the decision of the Board of Approval of this the right way, but is the request that the developer agrees on the holiday issues, and due to the fact that it is one of the houses right next to her house, that you try to be somewhat careful with the noise because of her children, her son, which is in the house, which does have a problem. Because in the beginning, that was a major issue, and we try to make it proper. So I think if we made a decision and put something like that, you know, if they'd be, you know,
I see where you're going, and I think the idea is that while I agree that the Appendix A and all of the conditions in it, because there are many, shouldn't apply to the first 2 lots. I think that's your bigger issue, is like if all of those apply, it's really going to get mucked up. Would you agree just to a simple, you know, hours of operations for loud construction? I don't want to tie your hands of people inside painting and doing tile if it's not loud and objected to, you know, causing an issue around the neighborhood. But if there's, you know, cutting, sawing, hammering, demolition, digging, loud activities, if it's a loud activity, it needs to follow under the same hours of operation as Exhibit A.
I'm okay with that.
Any,
that's it.
so. I'm thinking,
Any other questions? That it? Everybody agreeable?
No, that's fine. I think council made, very good points. It's obviously you can't put a box around lot 3 and say this applies here, but not
But just
the other 2.
that the only, sorry to continue.
The only question in front of us?
So this would mean that if we were just affirmed, that would mean that the construction of a single-family home on Lot 1 and Lot 2, that the construction couldn't go past 2 p.m. on a Saturday, and it couldn't happen on a Sunday or a federal holiday. And if it's going to only take a short amount of time to just build a single-family home anyway.
No, I think affirming the building commissioner's thing affirms that the entire special permit and the conditions apply to those 2 lots too, because that's what he's citing to create the violation.
Well, we could say that,
I would rather not affirm that, because I don't want, conditions 23 through whatever there are, you know, to apply as well. I don't think that's appropriate.
We could
But I
say,
think we can deny with the stipulation that they will then, going forward, have this rule. Can we? Town council? Can we deny it and then institute a new condition, or I don't know what we
No.
can do here?
Can you deny it, wait, can you institute a new condition?
We deny it subject to an agreement?
Deny the appeal.
Deny the, uphold the appeal, deny the violation.
The building inspector.
You would best be served to consider whether or not you would be upholding the building commissioner, but at the same time, if the developer and council have a resolution in the future, I mean, unfortunately, your board is, you can listen to this publicly, but you really can't totally decide that. It's got to go back and to the building commissioner for his zoning interpretation on whatever they propose to you. You can enter it into the record as part of the ultimate decision, but that has to be worked out with the building commissioner. Because again, it goes back to him. What is this is a little technical, but what's appealed before you is a noise violation on a federal holiday for which a citation, a notice of violation was issued. Now, either it existed or it didn't exist. If it did exist, but you think that there is an opportunity to resolve this in the future, then some of your decision can reference that back to the building commissioner. Or if you attempt to overturn the building commissioner, what would you be saying in lieu of his determination?
Well, I think the part of the building commissioner's notice of violation is the reference of the entire Exhibit A of the special permit. I think that's the issue. I don't think everything in that Exhibit A should apply to the two single-family lots. I do think, you know, a slightly modified hours of operation as to what's in there should apply out of consideration to the abutters, but it's not, it doesn't exist yet.
And it's not before you. As, in terms of an adjudicatory process, that issue is not before you.
Okay.
It's the issue of the violation.
so can I just suggest something that I think addresses your concern, Craig? So, I mean, I don't know if there's agreement amongst us on whether the hours of construction apply to the whole site or just to, they apply to lots 1, 2, and 3, or just to lots 3, but, I mean, one thing we could do is we could affirm and then say in our decision that, in other words, we're not overturning anything Mark did in this notice of violation, has really no practical effect, because what happened on in October happened, and there's nothing that can be done to change that, but just say, we don't make any finding that the conditions other than those relating to hours of construction apply to any future construction on lots 1 and 2.
But it does have a slight difference. Like on Lot 3, they can't even go in and paint past 2 PM on a Saturday. Even though it doesn't bother anybody, technically with this condition, they can't do it. And no other single-family lot in town has that restriction. And that's the issue I'm having, because it is, I mean, if Mrs. Arsenault was building these things, would we really tell her, you can't follow the same single-family construction practices that everybody else does?
I hear what you're saying, but just another concern I have is we've had a lot of hearings where we get to this point, and then we talk about conditions, and we've got an hour of discussion, we come up with kind of complex conditions, so.
But I think from town council, we can't institute a new condition.
I have a suggestion.
Okay.
No, and to reiterate, I think that's correct. If you're finding something in this review of appeal, if you find something that affects the subdivision or affects the neighborhood above and beyond the violation before you, it can become part of the record, and that information can go back to the building commissioner. And the applicant's counsel and anybody can go to the building commissioner and talk to them about the interpretation of the regulations as it relates to the subdivision.
So you
That's the solution beyond your determination.
So you interrupted Mr. Catanzaro was
Oh, I didn't hear
saying
him. I didn't
something.
hear him. He must have been speaking so softly.
He always interrupts me.
Sorry.
Suggestion is, okay, because you're in this quandary, I mean, we're not content with you affirming that violation notice, because it almost doesn't make any sense. But regardless of that, Mr. DePietri has expressed a willingness to comply, okay, with certain noise standards, let's say, so long as he can work reasonably on lots 1 and 2, like other homeowners or other builders can do. So what I would suggest is perhaps we continue this hearing, okay? And with the, okay, and I don't know if we need some extensions, just continue the hearing, all right? And then it's to be, if, after the houses are built, okay, the exteriors are finished, okay, we can come back and maybe you can do what you have to do. But again, we just don't want to be handcuffed unlike any other builders in town. And if you continue the hearing generally, if there's no more complaints, we're telling you what we're going to do. We're not going to make noise on those days, okay? We're not going to do that, but we don't want to be handcuffed by not doing any construction, interior construction or exterior construction that doesn't make any noise. You know, it gets around the problem of either, you know, you say you uphold them, which is inviting an appeal. You deny them, it's inviting an appeal. And, you know, we would rather agree to something, and if we can't agree to something in the context of a decision, we can certainly agree to something in the context of, let's continue this.
I think-
Hold on, I recognize Mrs. Brasio.
Thank you. My concern with leaving this open is you're now holding the building inspector to a standard of, what if there's another violation? You've now left this open. Again, all that anybody wanted was the time conditions, and to be clear, the conditions, the hours are 7 to 6 during the week. Whether that's inside or outside, it's not specified. Those are the hours. On Saturday, it's 8 to 2. And for the most part, those hours have been working all around. You know, there haven't been that many complaints. I think most of the complaints have been deliveries coming after hours. So I don't think, again, we wouldn't be here today if this didn't happen on a federal holiday. So, you know, that's the issue here, and how you want to resolve it. I think you're hamstringing the building inspector by leaving this open. Because what if there is another issue? We go to him and what, we come back here again? You know, I would hope there wouldn't be. I'm hoping after this that it's great.
It looks like Mr. DePietri had a...
So, Mr. Chairman, I don't have any issue with the hours of operation. What Lisa's talking about, I could be working all the way at the back of the unit, inside painting, and the guy could be there at 3 o'clock on a Saturday. No one even knows he's there, but she knows he's there, and she calls.
Now, that's
He's
what
not
the
making,
permit says.
that's why I don't want to have my hands tied on these two lots, 'cause that's what happens. 2:05, she sees a truck in there, we get a phone call. Now, it's nothing but, they don't speak
And then it's
English,
to the
they
hands of the building
don't know how to tell time, half these guys. It's hard to corral 50 subcontractors out there, and it's a pain.
Excuse me, that is immaterial. There are specific time guidelines, well, I understand, Bill, I understand construction people. My husband's in the business.
I hear what-
I
let's
totally
Let's just
understand it,
go
but there,
one person at a time, and I don't want this to become
sorry,
a
but
shop.
there were guidelines and there are guidelines, and the guidelines are there for a reason, and it's not 2:05. I would be happy, I don't want to go down that road, but I would be happy to supply 5:30 and 6 o'clock stuff on Saturdays. So again, I don't want to go there. I don't want to rehash the past. I want to make this work going forward. We all have to get along. This is our neighborhood, and he has a right to build in this neighborhood, and nobody is disputing that. We just want certain conditions that affect the neighborhood to apply as they were done and why they were put into the conditions on this project to begin with.
May I speak? Marnie Houlihan, 26 Clifford. So the two comments that I want to make is Mr. Catanzaro's request, I think, would set a precedent, which would question kind of the integrity of what we're trying to do here in a town, and to keep something open and extend does place a considerable burden on our housing inspector. our building inspector. And I don't think it's a wise decision that we should even consider this as an option. The second is part of the conditions and what your role is at ZBA. I'm not sure who made this decision, is you are supposed to carefully review the conditions as both parties agreeing to this. These were accepted, signed, and agreed to. So I feel that your job is to uphold the conditions that are forward, that the building inspector has put forward to you to consider. I don't think we reevaluate because it's a single-family home. It's still part of the project. Thank you.
If I just make comment on that, because the point that I tried to make earlier is, I agree with what she said. It applied to the 15-unit condominium project. We never talked about building houses on lot 1 or 2. We never talked about taking down the daycare center. It wasn't even discussed. And again, you can twist it any way you want. These conditions were written and agreed to because of the construction of that project. And again, I mean, I've said everything I could say twice already. That's what the intention was. So if that's what she's talking about, we agree. But that's what it is. It had nothing to do with 2 single-family homes. We didn't even know we were going to build 2 single-family homes. There was a point in time where there was daycare center was going to stay up. So it really, you just got to look at what the planning board wrote. And it's clear they wrote that to be applied to the condominium project.
All right, I think Mr. Robbins has a comment, and I think we should probably wrap
Yes,
this up and start.
just, I was able to do the math on this. I incorporated in the Stonebrook Court Road, and I believe it matches up with the planning board decision. So I believe it's a typo. It's map 15 parcel, it should be 15 and 16, which totals 8.34 acres, and I came up with, and again, math is not a strong suit, but I have literally tried to check it 3 times, and I come up with just 8.4 acres. So to me, the way I'm looking at the subdivision map that was approved, it would include lots 1, 2, and 3 with respect to subject property consists of 15 and 16, total acre is 8.34. Just to please have someone double check that, but I just wanted to bring that clarification.
Do you have one last comment? Is it repetitive of something anyone else said, or? Okay, all right, okay. I'm just trying to guide the discussion, that's all.
Majid Yazdani, 16A Bantry. So, not actively involved in this issue, but as an observer, I see this as the spirit of the conditions. The spirit of the conditions is to try to protect the neighbors, to try to protect the child that's living as an abutter. And just because those conditions don't apply to lot 2 doesn't mean that her situation changes or her conditions are different. So the spirit of the conditions is to protect the neighbors, and I think that's why it should be applied here, that lots 1 and 2 should be included in this conditions that have been applied. Thank you.
Thank you. And at this point, I think maybe we should just see, I know it sounded like Craig had an idea, and I don't know if it has support of enough people. I don't know how people want to approach this, so let's just open it up for a discussion about what the board wants to do.
Well, I think what I'm stuck with is you can't. I think the problem here is you can't apply all these conditions to lots 1 and 2 because they were clearly written for Unit 3. I do agree with the abutters that the intent and the spirit regarding the hours and the effect on the neighborhood should be the same on 1 and 2, but I'd be concerned with saying all, and I think that's where the decision gets into troubles to say that all the rules apply, because I don't think they do. I think the intent was clearly the neighborhood shouldn't be impacted regardless of which lot you're working on. So that's the problem. That's what I have a problem with, is the statement, these rules apply to the entire development, including the newly acquired former daycare and adjoining lot, AKA lots 1 and 2 on site plan. That's what I have a problem with. So I have a hard time supporting that statement. But I do agree that the intent was they should not be creating that level of disturbance on a federal holiday.
So what I was thinking, it was just affirming it, but saying that we don't make any finding that that all the conditions in Appendix A
Right.
apply to
Okay.
any construction of a home on Lot 1 or 2.
That's,
I think
I agree with that.
the proper way about, and which is brought up, is the fact that those conditions have nothing to do with these 2 units. And the issue of this is that we agree to do that, and that we take and make the recommendation that if there are issues, then it's discussed with the building inspector. The building inspector is very aware of things that would be going on, and he presently is under these conditions because, but we say those conditions are no longer good, and then he can make the regulations that he wants proper for you to go forward.
Debbie, what do you think?
I agree with Mr. Williams that I'm a little bit troubled by that statement also, that the rules apply to the, to all 3 lots. But I also think that the site plan is construed of the 3 lots. So I'm a little bit conflicted. I'd like to take his remedy and say, can we just accept his remedy and have no finding or something like that? But I think I like the decision, you know, the idea that, can we have no finding, or do we have to vote yes or no against this violation or appeal?
So,
I'll only say that that's not a normal determination by a zoning board of appeals. I think you're compelled to make a decision one way or the other.
Okay.
And Mr. Chairman, if I could just, something that Mr. Murray has just stated, the site plan approval, which came down the same day as the definitive subdivision plan, incorporated the same conditions. Okay, I mean, they stapled it to both decisions, same thing. That decision said that the site plan, which you're referring to, which is reviewing that site plan, is for Lot 3, for the 15-unit over 55 condominium project. I didn't write that. The planning board wrote that, okay? Because that was the culmination of what went on for weeks of hearing. These conditions were for that project. However you vote tonight, we just don't want to be handcuffed with our 2 single-family building lots with all these conditions. That's the bottom line. We just want to be treated like every other builder, okay? And, you know, to say, well, this...
We'll respect the holidays and Saturdays.
No, but that again, they can't impose conditions on, I'm hearing now, okay? I mean, we're agreeing to that, we're telling you that. If you can figure out a way to make that as an enforceable, that's fine.
I think what Aldo is saying is just, please correct me if I'm wrong, in your legal language was saying, don't worry about all these things that might happen in the future about whether every single condition in Appendix A might apply to construction of on Lot 1 and Lot 2, because it's not an issue unless it actually comes to the building inspector, and then he would make a decision about that, right?
But why wouldn't that be res judicata? If you uphold this decision, aren't you saying that, hey, this thing applies to Lot 1 and 2?
I haven't thought about that much, and hopefully there won't be too much litigation about something like this, but.
Well, I mean, that's our problem.
All right,
I mean, honestly, my view is although we agree in the spirit that they should be dealing with the noise issue, if we really do have issues with saying the entire set of conditions apply to Lot 1 and 2, I don't think we can uphold the violation. I think we need to side with the appeal.
but just Craig, this is not like creating a precedent that now you can't construct a single-family home in the town of Southborough, and
No, not a
you have to
precedent
be,
there,
you
but-
have to be bound by some hours restrictions. It's just it would just be for these 2 lots that were part of a much bigger parcel that were in a subdivision approval that
understand.
had these conditions. You could
But
read,
again,
in my view, you could read it kind of different ways, and, I mean, from my just observation of the site, once the 15 units, that is a lot of work, okay? The 15 units, once that's done, a lot of the generally the noise complaints. That's also the part that, the two lots, those aren't ones that are abutting Mrs. Bracio's home. So with the concern about her son, those would be,
Well, but they're directly across the road from her.
they are. I mean, I just think the project is, I'm not minimizing the work required to build Lot 1 and Lot 2, but the big effort here is largely done. And then if the construction of the single-family home on Lot 1 and Lot 2 goes a little bit slower than the others, I don't think it's that big of an impact, and it doesn't mean that, if the applicant buys another just single lot,
No,
you can develop whatever you want, whenever you want.
I understand that, but every day you don't finish is another day that you're carrying interest and you're carrying costs on the property. And if it's not required of anybody else in town for a single-family lot, why are we requiring this developer?
We're not requiring it, we're just interpreting what the planning board did 4 years ago.
I know.
But that's the problem. You are interpreting what they did, and when it's clear that that's not what they intended. I mean, and so at some point, I think you gotta step to the plate and say it. Okay, and like Mrs. Braccio pointed out, it's only the timing that's been the complaint. These guys have been sensitive to the neighborhood, I mean, to a certain extent, and we will continue to be. And, but it's like.
Perfect.
No, nothing is
Because it's-
perfect, okay, and we understand that it's
Very
not perfect.
intense.
But, again, you do what you want to do, Mr. Chairman, okay, and you're basically saying, hey, even though the document doesn't say it, it makes sense for us to interpret the document to say it. Well, we don't think so. We think you should read it, look at the other decisions, look at his letter and say, how the heck can we uphold
Well, the
this?
thing you just held out, what's that?
That's the site plan approval.
Okay,
Issued the same day. It's not part of your record, but it's there. No,
okay.
I mean, it's, for whatever reason, when I
Yeah.
filed this, I
So
didn't
just,
attach it.
the thing that we got had
Wrong plans in it.
wrong plan, something from Maynard.
Right.
Yeah.
No, we know that.
Okay.
That was all Karen's fault.
No, it was my boss's fault because I took it in.
Okay. So I was very confused by that.
Us too.
Yes, so were we.
Okay. All right.
But
The
that's all I
other,
have.
the other issue that should come up is the fact that the biggest noise issue was tearing down those other buildings and which are done and gone. So, to build the units, it's not a major, not as bad as what's already happened and been done and gone. Because that was a major issue, which I've heard from different people when they tore it down with the machines and stuff, the way they did it. But that's done and gone. And
So, do you think okay, this can be just the last point, and then I think I'm gonna make a motion to close the public hearing.
Understood that any single-family home isn't part of these noise restrictions, and there are no time regulations in the town. You can build 24/7.
Well, that's the very, I'm sorry to interrupt, but that's the very issue we're considering, right?
Correct.
Okay.
But this was a subdivision approval for 3 lots. One of the abutters has a child with sensory issues, and the planning board and the zoning board of appeals were very sensitive to that. That is why those restrictions were put in place. They probably wouldn't be put in place if the proponent bought a lot somewhere else where there weren't abutters with those issues. But that is why there was sensitivity in this particular project.
Okay, so I'd like to make a motion to close the public hearing, and then,
I'll second that.
just that, in voting this, that means that, we can't have a dialogue anymore. We just gotta go into deliberative session. So you second?
Yes.
All those in favor?
Aye.
Those against? Okay. So, David, you wanna say something?
No.
Okay, I just saw you click
I'm
the
just
button.
ready.
I'll make a motion. I have no idea if it's gonna prevail. I'd make a motion to just affirm. Just affirm the building inspector's decision, and then whatever happens in the future, I think it's extremely unlikely that no one's gonna construe this to say that, some of these things that clearly have to do with the 15 unit apply to lot 1 and lot 2. So I would make a motion to just affirm it.
What do you mean by that?
Affirm just means we do nothing. We don't disturb the fact that this
The
notice
motion
of
would be to
violation
deny
was
the
issued.
appeal. Right?
Yeah, that's the essence of
Okay,
it.
deny the appeal, same thing. Yeah, same thing. Sure.
Yeah, you could approach it, deny the appeal, or you could approach it, affirm the building commissioner's determination.
It's the same thing, right?
Exactly.
Okay.
So I make a motion to deny the appeal. Is there a second? Looks like there's no second. So, someone else want to take a stab at it?
I make a motion to approve the appeal.
I'll second it.
All those in favor? All those against? All right. So, you won, because you needed 4 votes.
Thank you.
All right, that ends the hearing on this, so we'll get you a decision. It's going to be pretty straightforward.
Mr. Chairman?
Before you make a motion to adjourn, we
I'm
have
not.
minutes.
I'm making a motion to approve the minutes
Well, let's go through them first.
for the September 27th meeting.
You're done, you're done.
Did we, gentlemen,
Well,
lady, we make a decision on the September 27th minutes? You got a copy of that?
I did, but I wasn't here, so I'm abstaining.
Oh, yeah, you weren't here, where were you? That's the first time you ain't been here.
I had a public meeting for my
Craig,
project
what
in
was your
Cambridge.
motion to grant the appeal or
To approve the appeal.
to approve the appeal? Okay.
The other thing is, chairman. All right, you ready to do this?
So the next item on the agenda is approving minutes.
Minutes, December 27th.
But before we go on, I would be interested in Karen, you attended something, a 40B seminar Monday night?
Yeah.
So I'd be interested in your telling the board about, was there anything interesting learned or?
Yes, so
Sorry to put you on the spot.
I know, I don't remember the name of so I attended a seminar, 2-hour seminar on 40B permitting process. And that was in Framingham. It was about 2 hours. And I forget the woman's name, Mary Barrett, something Barrett.
Was she from the Department of Housing and
Yes,
Community Development?
Mass Housing Partnership.
Okay.
Which is
So,
not DHCD, it's a different organization.
so she,
Okay, yep.
she talked a lot about project eligibility and how they go about doing that for developers, and then the permitting process. And she talked a lot about the Zoning Board of Appeals and their roles and responsibility in permitting, comprehensive 40B permitting. So it would have been, I'm sure they'll do it again, and I have some information, but I found it to be really informative, and it was directed toward Zoning Board of Appeals and their what they're supposed to do, their directive.
And there's a kind of a related seminar that Karen and I attended last March.
Yep.
That was held at Holy Cross College in Worcester, and it was
Citizens planning.
Citizens Planning Collaborative was the sponsor, and you go, and the town will pay for your attendance. And there's all sorts of seminars, a grab bag of different seminars about duties of ZBAs and planning boards, and there's a mix of kind of basic stuff and then leading edge stuff about medical marijuana and things like that. So I would encourage other people to attend. I enjoyed it, and
And you can pick what you want. You pick modules, 3 modules for that day. So whatever your interests lie, you can sign up for those different modules. And they have a big lunch, and you just see a lot of people that you know, so it's a good thing.
okay.
There's another issue with 40B projects that the state is starting to work on to continue it from 15 to 20%. And if they do it, the town of Southborough will have to be allowed to build 685 units in the town. And it's process that is going to be in January, that they're going to start publicly working on it to increase it to 15 to 20% for the state.
So I'm now taking a look at the September 27th minutes.
Why? You're not?
I was just trying to change topics here.
Starting to look at the minutes.
I've looked at them, and I will make a motion to approve them. And there was just
I second.
3 of us, right? You were with us that night, right? Yeah. All right, we have a second on it.
Okay, all those in favor? All those against?
I make a motion that we close, oh, he wasn't here.
Wasn't here.
Okay, great.
4-0-1.
All right. I make a motion that we close our meeting, public meeting.
Motion to adjourn.
Do we have anything else, Andrew?
Second.
Nothing.
You know what? We will set our next month.
Okay, is there anything in the pipeline?
Yeah, I did speak with an applicant today that's looking to probably get on the agenda maybe the end of January. They don't have their application together yet, but they're working on getting plot plan and getting all their information together to apply for, I think it's going to be a variance and a special permit
That'll be all right.
on Northborough Road. So do we want to book something at the end of January?
Yeah, and you had sent out an email about the advisory committee
Yeah, so the advisory
competing with us for
committee
this room.
has decided to have Wednesday night meetings as well. So they've booked out for many months, 2 Wednesdays a month, so I'm in competition. So in January, I was able to book the 17th and the 31st. So whatever, probably leaning toward the 31st to give that applicant time. And then I'll erase the 17th, in the books, free it up for someone else
Okay.
to use.
So I know that we typically had always tried for the 3rd Wednesday of every month. I know Paul was a very big proponent of that. I generally agree with that, but I would be in favor of having the hearing on.
Well, advisory is already booked for the
Yeah,
24th.
So,
If we don't have
so
a choice.
that's why I said I think the 31st would be okay with me.
It's okay with me.
So whatever you pick, I'll.
I might be out of town.
I might be out of town. What about
So
the
there's-
first week in February? Let's see what else. I did take the liberty of booking ahead.
What about doing it on the 17th? That's just our regular time, and if it comes in, it comes in? I mean, we're
Nothing
talking,
ready yet for the
It's not-
17th.
well, that's still giving the applicant like 2 months to,
He
or a
says he
month.
doesn't
I
have
need,
time.
I need 4 weeks, Andrew.
For
I might
notification.
get it. I need 4
So they have
weeks.
2 weeks to get everything done.
For
So
the 4 weeks, that's right, so it's not gonna work.
we, 17 advertise.
I think the thing to do is leave it until the 31st,
you
and
know
then
what?
if
He
it
could-
has to be extended, you can do it
If that
after.
applicant does get his, he's
What-
got the applicant has some sort of arrangement with the seller to give him a final answer by January 17th. So I said to him, maybe you want to go back to your seller and get an extension to January 31st. So he must be trying to come to this board before he makes a final decision to sign the P&S.
And then it has to be extended, it can be done that way. But leave it there for now and see what happens.
So you're saying you want to put something on for December 17th or January 13th?
Well, let's see, we're, December, I have the room December 27th
So,
or the
so what if
13th.
we,
I think January,
what
because
if
that
we
applicant
leave
really
it-
didn't have his stuff together.
what if we leave it January 17th?
All right,
Yeah.
You suggest to the applicant that he put in his application, and if come January 17th, not everything is ready, he asks for a postponement, a continuance.
yeah, I don't have his number. He just called me today, so, all right,
Or he
Let's
falls
go with
into our
that.
normal
January
schedule.
17th.
let's go with that, January 17th, and if he does reach out to me, or maybe I can find his number somewhere, I'll see if that's feasible for him to
But
get
if
his
you do
stuff
it
You
that
can-
way, you can't change it unless you have a public meeting to change the time.
No, we can change it.
You can't, that's not legal. If it's a meeting dated for that date,
Once you
it has to
post
be a
it.
public meeting to
Okay.
properly change it.
You post it.
I think you're right. Once we schedule it, then one person, 3 people come and just take a
Yeah.
motion to continue it. But we could just schedule something
Right.
for whenever.
I mean, we'd have to come and,
January
Officially.
17th.
yeah.
All right, so was there a motion to adjourn?
I move that we adjourn the meeting.
Second.
All those in favor? Okay,